Mr. Mkhize, and I'll then proceed to Ms. Masetti. Ma'am, over to you.
Good morning, Chairperson. Good morning, Mr. Mkhize. Good morning, colleagues. And I would like to also greet the members of the public that are joining us for today's proceedings. Thank you, Chair.
Thank you, Ms. Masetti. Members, we then move on to the agenda. We've got an agenda that has been drafted, and there are 2 items for the open session of our meeting. May I, by a show of hand, get an indication that you support the adoption of the agenda as presented before us? Thank you, Ms. Masetti. Thank you, Mr. Mkhize. The agenda is adopted. On that note, we then move on to item 4, declaration of interest. Are there any verbal declaration of interest that members would like to make? If there are any, I would like to start first with the members and then any member of management. I do not see any hand. On that note, I would like to request that we complete the declaration of interest form that has been provided by the secretary and send the same to her once completed. On that note, then we then move on to the 2 items that are for our open session of the meeting. And these items relates to the regulation of the petroleum pipelines. We will start with item 5. Over to you, Ms. Mtoa, to just introduce the subject or the submission and then guide us as to who is going to assist the committee in presenting it. Over to you.
Thank you, Chairperson, and good morning, members. Good morning, colleagues and members of the public. In front of us, we have Remabuso investment application for a license to operate a petroleum storage facility in Secunda, Mpumalanga province. Ms. Ngobeni, who is initiated, is currently on leave. Therefore, Mr. Untit will assist them in terms of introducing the submission. Thank you. Over to you, Mr. Untit.
Good morning, Chair, members and members of the public. The cover submission as uploaded states more details, but I'll just be highlighting some aspects. The investment cost in 3.1 is confidential, but it's within the REC mandate. The facility basically 36 pencil type prefabricated above ground tanks. There is a picture of that. They've been a wholesaler, the applicant, since 2021, followed the EIA processes, and there's evidence in the application and discussed further. This is 5 to 6 months, the processing time, which is well within our targets. The detailed motivation I'm not going to read is given in paragraph 5 of the cover submission. Then just the following salient points. Just to be clear, this application is not for construction license, and under that legal analysis section, we in the cover submission and also in the summarized, we provide the details on that, and then the colleagues can come in if there's questions from a member later. But it's inconsistent with the objectives of the Act, but as explained there, this application now seeks to a license to operate the facility. The tanks are not being operated pending the outcome of the application. There was also a site visit done by the team to check this. The engineering requirements, EIA, environmental management plan standards, all of that provided, and will also be conditions of the license. The admin technical and financial abilities is outlined, paragraph 26.7 and 28. Preliminary prudency, this facility will add, and this number is confidential, but you can see it in paragraph 32, is the number of intended potential users indicating capacity there as outlined. This should be positive for third-party access, noting that the applicant also, as a wholesaler, will also be using some of the tanks. The analysis is there of the 18 licensed tanks. I think important to note, this is the first facility NASRA licensed in more than 15 years or since its inception, in fact, storing diesel. There is another lubricant facility, but it also become the third biggest Mpumalanga facility, which you can see from the table and the market analysis. It's highly concentrated and dominated by the oil majors. So we have also not had any investment in Mpumalanga in more than, between 5 and 10 years for any new capacity, mostly because operators it's central to or close to the two inland refineries and therefore uplift and deliver directly. In terms of other objectives of the Act, we've listed them there. And then maybe important to note that although the BEE credentials may not be fully what to reflect what NASRA also seeks to do, and on a national level too, but that can be dealt with through the conditions of license to ensure that the party then develop an equity plan and submit that. I think subject to the comments and questions the members may have, I'm not sure if it's appropriate, then I can read it into the record now, Chair, or should I do it later? Thank you.
You can do it later. Let's just take questions from members or issues of clarity or points of enhancements that they may have on this particular submission. Members, over to you. Any issues of clarity that you may have? Mr. Mkhize, you may come in, sir.
Thank you, Chairperson. I think just to emphasize that this one was taken with a bit of a pinch of salt, noting that there was this oversight from the applicant. And really, it's a question that is difficult to address because it's a matter that then is left to be governed by legislation, which we think that in amending the Petroleum Pipelines Act, there should be consideration in terms of dealing with such matters. But as the law stands, this is the best way that was deemed feasible to take this matter forward. Thank you.
Thank you, Mr. Mkhize. I think from my side, Mr. Untit, you did touch a bit on the issue of the triple BEE credentials that you said, if I heard you correctly, they were not really reflective of what NESA would like to have. I was going to ask a question maybe linked to that as well in terms of page 6. There's a second bullet from the bottom, and we are saying, or the applicant is saying, their operations are aligned to national energy policies. I was curious as to whether did they give any indication in the application on the alignment of their application to the issue of gender equity? Are they aligned to those policies or not, or is this one of the factors that still needs to be discussed with the applicant together with the triple BEE? You may come in. Thanks.
Chair, I noted Ms. Masetti's hand.
Yes, I see Ms. Masetti's hand now. Sorry. Ms. Masetti, you may come in then.
Thank you, Chairperson. Chairperson, just one question from my side. It has to do with the third-party access. It's linked to the question on the triple BEE, but also for purposes of the Act. For now, it talks about the historically disadvantaged persons or individuals. So I would like to understand what is the status with regards to this application insofar as the applicant has to grant third-party access. Did they provide any information as to how they're going to allocate capacity for third-party access, number one, and whether you have checked in terms of the regulations which requires us to consider allocation of capacity or third-party access on a non-discriminatory basis. So if I can just get clarification on those two things with regards to what is the submission and commitment made by them in terms of their approach or mechanism for third-party access. Thank you.
Thank you, ma'am. Over to you, Mr. Ontit.
Thank you, Chair. Maybe if I can start with the last question. In terms of third-party access, they did not include a draft or a proposed allocation mechanism, but that's not a requirement in terms of the Act and the regulations. They've got 6 months to submit this for new facilities and 3 months for existing facilities. So that will be a condition that we will enforce to ensure that they submit the proper or the official allocation mechanism to be considered by the relevant subcommittee. However, in the application, they made it clear that they've signed letters. Maybe Mr. Sukupasi can just confirm the numbers, but there's at least 3 or 4, even 5 potential users, which are third parties, that provided intent to store. So they are committed, although they'll be using a percentage of the 18,000, which is quite significant capacity based on being the third biggest. They will then have to submit their document within the next 3 months, and we will enforce that. I think in terms of the BEE, I think Mr. Mkhize did indicate some challenges in the Act. The current reading of the Act still refers to historically disadvantaged South Africans. We do know that the BEE Act subsequently was promulgated, which specifically referred to Black person. But in terms of let's say then HDSA, it's 100% owned by a lady in terms of the CIPC documents that they also submitted. So I think that is a matter we have been engaging with the department to get that aspect going. I apologies, I may have missed your, so I'm not sure in terms of gender, CEO, if I've addressed that, but as I indicated, there will be a condition. In the conditions, we will require the party to submit a, let's say a plan to address the equity, as has been the case on at least 2 or 3 other similar cases where the applicant were, I think they are level 4, which is the requirement NASRA typically uses, given the challenges with the legislation as it is, but to improve that further, maybe then including also of other groups, demographic groups. So I'm not sure if I've answered your question, CEO, and then maybe Ms. Masetti, I may have missed your first part in terms of your 2 questions. Apologies.
Let me check with the members if they're fine with your responses. Ms. Masetti, Mr. Mkhize, if there's anything that you want to follow up on.
Thank you, Chairperson. Chairperson, I am covered a bit, but it is important, particularly on the market analysis, that the part about third-party access be enhanced there or be included as an indication that at the time of taking the decision, as we know that the law requires that third-party access be granted, that we do mention that information at the time of this analysis, that information came to our attention that there was some interest of people who wanted to connect as third parties, and therefore it is that will be important for purposes of access, but also for purposes of competition in that space if there are already 5. So I think in the market analysis, if that can be mentioned, and therefore it must be emphasized in the end that the party will be required as part of the what you call conditions of the license, that they submit their mechanism, the allocation mechanism for third-party access, which in terms of the Regulation X, it requires that it be non-discriminatory. Thank you, Chair.
Maseti, I see Wabu Sokopas's hand is up. You may come in, sir. Zuki.
Yes. Morning, members of the public. Just wanted to add the unit maybe required me to sort of add in his response. So it may have not come out clear in the market analysis, but to Ms. Maseti's question, the business model of Remabuso is split into 2. Number 1, they operate as a wholesaler, and number 2, they seek to operate the business of renting out storage, right? So if they rent out the storage, then in my opinion, the third-party enforcement is not necessarily relevant, or rather, it's not an important factor to consider, because they will be in the business of renting out storage. Unlike a situation where a player is vertically integrated and they have no interest in accommodating other players because they compete with them downstream. So Remabuso will be in the business. They have an interest in providing storage. So in other words, third-party access enforcement is unlikely to be that much of an important issue. Just want to clarify that, and just to add that there are 2 customers which I want to mention. Of course, the information is confidential, and that have shown interest in the usage of the storage that Remabuso has constructed. And the Remabuso is also substantiated the allocation for its own use by providing a letter at the wholesale level, a letter of interest by a customer to supply the diesel to. So in other words, there is about more than 80% of accounted for storage, which Remabuso is intending to use. So I'm not sure with that explanation if the question that you had still persists, in that an allocation mechanism still needs to be submitted. Yeah, so I wanted just to, yes, maybe let me pause there.
I think that's noted, Mr. Sokopa, so thanks for that. But I think what Ms. Maseti was saying, even if their business covers the issue of storage rental, let's put this as an emphasis to say that we will make that part as one of the conditions of a license. That's all that she was saying. But thanks very much for the explanation. It does help. So the point was just for enhancements from my perspective. But I saw a hand again from Mr. Mkize. Mr. Mkize.
Yeah, I think all that you need to be capturing there is to enhance it and clearly indicate, even in the submission, that it will be required of them to provide that allocation mechanism, and as far as third-party access is concerned, and as well as the fact that the BE as part of the HDSA in terms of regulation, I think it's Regulation 8, they will be required to submit that. I think that will then be able to cover everything. Thank you.
Thank you, Mr. Mkize. With those summarized additional conditions, Mr. Untit, you may read the recommendations into the record on paragraph 14 on pages 9 to 10. You may come in.
Thank you, Chair. Just let me scroll there.
Let me read them.
No, I will read. I'm ready, ma'am. Okay. The recommendations is outlined in paragraph 14. Point 1, it is recommended that the Regulator Executive Committee consider and approve A, the application by Remabuso Investments Pty Limited for a license to operate a petroleum storage facility with a combined design capacity of 18,000 cubic meters in Secunda, Mpumalanga province. B, the decision and reasons for the decision document attached hereto as Annexure 1 in the submission, and C, the associated license conditions for the license PPL SFF3 35725 attached in the submission as Annexure 2.
Okay. Thank you very much. Members, by show of hand, can I get an indication that you support the recommendations as read into the record? And thank you, Ms. Masetti. Thank you, Mr. Mkhize. I also support the approval. We then move on to our second, which is the last item for the open session of our meeting, which is item 6. Ms. Mtwa, I think let me just go straight to Mr. Sentimule in the interest of time to allow him to have 2 minutes to present the submission. Please do take it as read. Over to you, Mr. Sentimule.
Good morning, members. I'll undertake this and try to be quick and utilize my 2 minutes properly. So the purpose of this submission is to request the Regulatory Executive Committee to approve the TNP CACM submitted in compliance with the requirements of the RLMs. TNP submits this CAM on 17 April 2025 in compliance with the requirements of the RLMs. The CAM submitted by the TNP was evaluated by the RLM specialist. The CAM was deemed to have met the criteria set out in the cost allocation manual. So I think to the members, I need to point out a few things in terms of the submission in front of us, because it's quite of unique compared to other. What we need to understand here is that the TNP application in terms of the tariff, it's a rental recovery approach, which means the single point mooring and the provisional mooring for tariff application submitted by TNP were based on recovery approach, which consider the direct cost of the terminal of the operator, which are, of course, your maintenance, your marine cost, and your rental expenditure. And whereby you find that the methodology undertaken by the TNP, they forgone for a return on investment because they are operator. So given that approach adopted by the TNP, there's been no allocation for cost, as in the case of rate of return approach. So then what we're seeing here, the only costs that have been considered for the tariff application are that of the direct cost, because you will find in here Petro SA is the operator of both SPM and CPM, so those costs are not involved. So when you look at the current CAM in front of us, it only have those indirect costs which I alluded to. So I think when members are talking to the things, so also what I should emphasize is that Petro SA is also part of our licensee who have to comply with the RRMs. I'm working with Petro SA in terms of the compliance. They are part of phase 4. So as a result, that indirect cost will receive them when your Petro SA comply with the requirements of the RRMs. And as a result, it is recommended that the Regulatory Executive Committee approve the TNP CAM submitted in compliance with the Regulatory Reporting Manual. Over to you, Chairperson.
Thank you very much. Members, the submission is before you. Are there any questions, issues of clarity, or points of enhancement on the submission? There is a hand from Ms. Masetti. Ma'am, you may proceed.
Thank you, Chairperson. Chairperson, I'm a bit confused as to how this is going to work, especially because from our side, what we know is that TNPA obviously is an authority in the ports. Now, it would have been helpful if we clarified properly in terms of the scope of TNPA participation in the operation of the infrastructure or facilities in the ports, so that once we are told in terms of the scope of their operations and the infrastructure that is owning therein, we will then be able to at least get a better sense of the cost drivers that must be included in this cost allocation manual. By understanding the cost drivers, it will be much easier for us to then accept or approve this cost allocation, because we'll at least be able to say that these costs are clearly identifiable, they are accurate, and they have been assigned accurately to where to what they should be, or to where they should be. So at this point in time, I'm not so clear as to the scope of operations of the infrastructure by TNPA in the ports. This is even worse when now we're also going to have Petro SA, another SOE, which will also do operations. Now, you do need then to delineate the scope for both of them. You are also doing that so that we avoid any duplication of cost, to the extent that these two SOEs are going to, be operating and helping each other, and also and where there are synergies between the two of them, at least those synergies should even be able to assist in terms of cost effectiveness. Now, we are not getting that. At least I am not getting that, and if I'm approving it just because it is here, and I would not want to do that. I would want to approve when I understand exactly what is going on, when I understand exactly that when they arrived at these cost drivers, what did they take into consideration? What will then make the decision makers today comfortable that this is a proper cost allocation manual? The cost drivers were clearly identified. The accuracy of the cost were clearly verified by the team. And now they have not even looked at the Petro SA1 to check if there will be any duplications and what role Petro SA is going to be playing, such that we make sure that what we have before us, we will not find it in the Petro SA, or will flag it. By the time we get to the Petro SA1, we make sure that it's not going to be included. So I'm very worried about that, Chairperson. I think the questions are simple, and I've clarified exactly what makes me uncomfortable, unless I can be clarified. Thanks, Chair.
Thanks, Ms. Masetti. I do not have any questions from my side. I don't see any other hand. Mr. Sintumile, do you want to assist with the response? Thanks.
Yeah, thank you, Chairperson. And I will also request my colleagues from Tariff Division to come and support if there's any different view on what I'm going to say. To say, Chairperson, this has not been an easy type of journey from implementation plan to where we are, to the point where the TNP came to request through the FTRM office, actually not through our office, to request for deviation, not to submit. That's how far we have gone with TNPA. And on what Madam Masetti have raised, I'm well aligned, if I have to say, because I don't want to find myself being able to defend undefendable, to say if we can be allowed time so that we go and enhance our submission, because there's an element of Petro say we have not complied, and then also the issue of maybe cross-substantiation of the cost or duplication of the cost in that regard. So to me, I would say I'm aligned. I think there is a need to go back to the TNPA and require the details as requested by the member, so that member, when making decision, they've got all facts on the table. So I do see that gray lining being indicated by the member. So I'm aligned, and I'm willing to say, if possible, I don't know, maybe allowed to go back and enhance the submission and come up with new revamped submission which can address the members' comments. Because for now, what I was dealing with members, we gave a TNPA a period to say you comply by this period after we rejected their deviation, which also within the RRM Volume 1, so at certain stage, it's not well documented. So allow us to go back, revisit the submission, consult TNPA, and also look at the issue of the Petrosay, so that we come and represent this submission to you. Over to you, Chairperson.
Okay, if that's what, as a team you want to do, I would support that. Members, any issues on that? Because I think the points that have been highlighted are critical. And I think Ms. Masetti highlighted the issue of the scope of TNPA to operations and the costs that were taken into account, issues of subsidies, and whether we've looked at Petro SA as it is linked to also to TNPA and other entities. Mr. Mkiza, I see your hand. I was going to, you may come in.
Yeah, I'm just not so sure in terms of the route that you are taking and what kind of improvement is expected. I'm not so sure because as TNPA, they've got a dual role at the end of the day. Because if you are a landlord, there are certain parts of your infrastructure that would revert to you in terms of running them whilst you don't have tenants. They are both a co-jurisdictional authority as well as a licensee in as far as NERSA is concerned. And then they will have a situation where they've got agency agreements, which actually to have a state-owned entity in the space of petroleum operations, being the one that is fulfilling that duty, that would be best. You know, there's one school of thought that says that actually the state-owned companies should be more prominent in the space of intake of fuel into the country, especially now that we are more on the side of importing product instead of domestic manufacturing. So as to where this discussion is going, I'm not so sure, and because it doesn't help to send stuff back when there is no clarity in terms of what is it that is going to change fundamentally in terms of the mechanism that they've provided in terms of the cost allocation. Because it's a known issue. We have had also previously debates, and I would not call it debates, I would call it there have been disputes between Petro SA and Transnet, which we have stepped in to kind of resolved, because there are costs that are sitting outside of our regulatory framework and being imposed by, or fees being imposed by the post regulator of South Africa. So these are some of the things that we have dealt with, and this cost allocation manual will, in fact, if they then go on and fill up these RFRs, they will kind of give us some indication as to what is happening, which is going to unravel some of the things that are not so clear. So it just for my side to say, I would appreciate if I can have more understanding. And I think Mr. Sintumun, instead of coming head on, as well as the EM and the team, to respond directly to this issue, to say that you are going to send something must be relooked. Tell us how. Thank you.
I think, let me just allow Ms. Massetti to repeat what she had requested, or rather she has asked in terms of a question, and I think that will guide what action item needs to be undertaken. And I thought that the Sintumile understood that. But Ms. Massetti, I see your hand is up. Please, if you can also assist in repeating your questions. I have noted them down. I was going to summarize, but you may come in, ma'am.
Thank you, Chairperson. Chairperson, I think from your side as the Chairperson, you can repeat them later just for emphasis to make sure that questions that were asked by members, when members were unable to take a decision and understanding what is before us, how this is going to work, because that's where it starts. How this is going to work, because what is before us, the regulator, once we accept the functionality, the allocation of cost, we must be confident that the costs that are before us were accurately identified. And being accurately identified is also very different from what are the cost drivers that give rise to these costs that we have identified. Now, once you talk about the cost drivers, you have to delve into what will be the specific operations of TNPA in the facilities, so that TNPA can be compensated for operating or doing something that has value on the regulated operations. So we only compensate as a regulator the regulated activity that TNPA will be responsible for. Now, the submission also mentions that there is going to be Petro SA involved in this regulated activity. Now, the regulator must pause to understand what are these two going to do? Where are the synergies between the two, so that the cost drivers can be clearly identified, and what influences the level of the cost to be where they are? Are they too high? Are they too low? How are we going to know? This document is supposed to tell us. The people that compile these documents, and the document must tell us, so that we then say, once we then approve this, we can't go back and now say the levels of the cost that are there are not proper. They were overstated. This is not the cost driver here. It was simply put there and stuff like that. The discussion did not get to that level, or the responses are not there. And the member of the team immediately said he's just aligned with my concerns and never provided any response, and said he himself would request time so that he can properly understand, because he does not feel that it is sufficient, so that he can be able to clarify the questions that we are asking. So it means the questions and the concerns we've asked have not been responded to. That one is on record. It is very clear. I must also go back to the document to indicate what has been said by TNPA. The team has indicated that TNPA in this allocation, it simply took some of the cost or expenses that are going to be incurred by Petro SA, took those. They're also part of this allocation manual. Please go to the table and to the actual submission, and then it will tell you where this information has been combined. That also makes it complicated, because we don't have both the Petro SA cost allocation manual as well as TNPA to look at them together. then we can be able to say, no, this one, let's not allow. That one is already taken care there and all of that. That's one of the things that I said. Again, it could be that it's overstated or it's duplicated. Now, it also goes to say what TNPA is going to do is going to list its SPM and CPM loading facilities to Petro SA. So it's the listing. And it included only Petro SA expense allocation. You see, so look at that. That on its own is what I simplified in the explanation. They also go back in section number 8 of the cost allocation manual. Now I'm getting straight into data to say what are the problematic things here. So section number 8 of this document that we are required to approve says there are no overhead costs allocated to the regulated facilities as the facilities are listed out to Petro SA. These things are complicating the submission that is before us. So they are not there. And for me, I am a bit worried. And hence I talked about the scoping of what is it that TNPA is going to do so that we can understand what are the typical costs that will be incurred by TNPA, which NERSA will have to allow or approve for now and say they will be allocated as such. But how would we know? And then which one must be the ones of Petro SA, so that this one must not take the Petro SA and bring them here. And then there is nothing else there, and Petro SA is still expected to operate as an operator. I thought that is, and it's also on page 6 of the submission, if you look at that. So those are the things for me, Chairperson, now factually that are stated here, which make it difficult for me to understand how are we supposed to know exactly? Thank you, Chair.
Thank you, Ms. Masetti, and maybe I trust that that this Intumile, Ms. Masetti's presentation is very clear, and as well as to Mr. Mkhize. And I would like to really maybe to rule that we allow the team to go and enhance the submission based on some of the issues that are raised, and some of them that I have picked up was that we need to really have the submission enhanced to cover, to clarify the scope of operations of TNPA. And I think, Mr. Mkhize, you've clearly made it, you have made it clear that TNPA is a licensee in terms of NERSA mandate. However, there are linkages with other linkages in its operation with some of the other entities within the industry. And the clarity really sought is that in terms of what is before the committee now, can the team really clarify the cost drivers that are related to the costs that have been considered in this particular submission, and the fact that the submission TNPA, there's referral to Petro SA, and there is a need to say that if they are referring to Petro SA, how do we, in making the decision, we ensure that there's no duplication of these costs between the two entities? And therefore, then the team should at least have highlighted or enhanced the submission by providing the additional information on Petro SA, so that it makes it easy for members to really compare the costs that are presented before us. So that's just in brief, and I think really it will assist everyone to just to have an understanding that there are no duplications at the end when we approve this submission. And without some of the information that has been raised, it may be difficult for us to proceed with the consideration of this item. And it's my request is that let's just refer it, because even the authors themselves have said that there is some information that they believe they still need to enhance the document. I see your hand has been dropped, and I think on that note.
No, I know that, but for me, that's important is when things are brought forth before the committee, and then there is questions that are being raised. Clarity, responses should be provided by the presenters further, instead of just saying, I'm withdrawing. And I think that for me, it's important because it then informs the process of enhancements. But in the interest of time, I'll let it go for now. It's fine. Thank you.
Thanks, Mr. Mkhize. I think that's what should have happened. I think by the presenter's admission to say that he also believes that there's more information needed. I think that's really made us to come to the decision that let's just allow the team to have some time and go back and enhance the submission. I've closed the item. I don't know if you have any addition to make, because you yourselves have said that you request time to go in and enhance and cover some of the issues that Ms. Masetti had raised, and of which you also said you concur with them. Members, on that note, item 6 will be referred back to the team for further enhancements to cover issues that have been raised by the members in this meeting. And that was the last item on the open session of our meeting. Let me thank the members of the REC, members of management and support staff for assisting us to go through the items that were set for the open session. I would like then to also thank our stakeholders who have joined us to follow our discussion, and thank you everyone else. We have come to the end of our open session, and thanks once more, and the session is closed. We will proceed with our